you. Thank you, Mr. Chairman.
Thank you. Senator Coons.
Thank you, Chairman Menendez, Ranking Member Risch, for leading this important hearing and for your joint and clearly shared passion about this. As you mentioned, Chairman, earlier, you and I and a bipartisan group of senators went to The Hague, met with the prosecutor of the ICC, many of their senior staff, had long conversations about it, and then acted promptly and effectively in a bipartisan way and amended the underlying statute under the, I think it's the APSA. For many years, the U.S. Department of Defense and the U.S. government has resisted cooperation, support, engagement with the ICC because of a concern about the potential for U.S. service members to at some point be hauled in front of the court. We acted to amend that statute specifically in the case of Ukraine in reliance on the circumstances. Like many of my colleagues, I am outraged at Russia's conduct in Ukraine during this war. I believe there's been something like 88,000 documented atrocities, crimes against humanity. You've gone through them, my colleagues have gone through them, and I'm grateful for all the different international partners of the EU and the UN and the OSCE and the ICC. But I'm struck by two quotes from earlier in this hearing. You, in response to a line of questioning, said, "It's hard to imagine us standing on the sidelines." And you, Mr. Chairman, said the Department of Defense doesn't get to choose which laws it obeys. Help me understand what the challenge is here in getting our government to cooperate with the ICC. You put it well. They've never faced a challenge like this. Russia can be counted on, not just in the case of the Brazilian student, to infiltrate their systems, to attack witnesses, to undermine their capacity to successfully prosecute. We have a wide range of important resources we can provide: intelligence, documentation, financial support, operational advice, partnerships in terms of protecting witnesses. Why would we not fully partner with the ICC in this undertaking?
Thank you. We have had a long-standing objection to the ICC proceeding against U.S. personnel.
Understandable.
That objection exists. It guides my work. All of my interactions with the court, I have that as my lodestar, in essence. I think the fear is that if we, in this matter, assist with a prosecution that involves another non-party state, another state that has not ratified the ICC treaty, that we would somehow erode our ability to protect our own service members, because we are similarly situated in the sense that we are also non-party states. The reality is that that argument has no purchase before the ICC, and all elements of the court has already shown that. They have already proceeded against the nationals of non-party states in the Burma matter, for example, in the Georgia matter, in the Ukraine matter, in the Democratic Republic of Congo matter, where a Rwandan was in the sights at one point. So it has no protective power before the court. What has protective power, I think, is engagement, building trusted relationships, keeping lines of communication open.
And not committing gross atrocities.
And if there are credible allegations against U.S. service members, having a credible process so that we can say, we are handling this. We are handling this ourselves because our service members deserve the full panoply of constitutional due process protections under the Uniform Code of Military Justice. So I think that we can help in this matter and also maintain the protections that we have. And as I praised the amendments, they're surgical, they're carefully crafted, and they leave a whole number of protections in place that remain untouched.
Two other quick questions, if I might. The Alien Tort Claims Act, which I think is 28 U.S.C. 1350, was for some time viewed as exactly the statute enabling prosecutions or actions, claims for crimes against humanity. That has been narrowed. Why not legislatively strengthen that? Why not use that as the platform for action by Congress?
I think there is grounds to amend and revisit the ATA. It's a very old statute, right? I mean, it was drafted
among the
oldest.
At
the founding of our nation. And as you mentioned, the Supreme Court has narrowed it considerably with their doctrines of extraterritoriality. And so I could imagine some very discrete amendments to the Alien Tort Statute that would open it back up to individuals who have access to U.S. courts being able to advance claims against individuals or entities, so long as the 14th Amendment due process protections exist over personal jurisdiction.
Understood. We also met with the Prosecutor General, Kostin. What else can we and should we be doing to strengthen Ukraine's ability to investigate, to document, to prosecute, to hold accountable perpetrators of war crimes in Ukraine?
I think there's more that the Department of Justice could do if they had the resources to do so in terms of seconding their expert personnel to work side by side with Ukrainian prosecutors. I know the Attorney General is very keen to do that. He and the Prosecutor General have developed a very close relationship, very trusting relationship. And so while I'm working through civil society actors, through academic entities, through experts that have been drawn from the world's war crimes tribunals, we have a lot of expertise in-house. I can't fund that with the kind of funding that I have, but our INL office can help with the Department of Justice. So that would be another way that I think we could continue to assist the Prosecutor General in the momentous task that he has ahead of him.
Thank you, Ambassador. Thank you for your work in this area. Thank you, Mr. Chairman.
Thank you. Senator Young.